Why are labor laws so complex for union organizing efforts? Imagine trying to organize a group of workers when the rules keep changing and the process is full of hurdles. That's exactly what many workers face when they try to form a union. Labor laws in the United States are built on a long history of laws, court decisions, and regulations that have grown over decades. The main law that covers union organizing is the National Labor Relations Act, passed in 1935. This law gives private sector workers the right to form, join, or help labor unions, to bargain collectively, and to do other activities for mutual aid or protection. But how these rights are applied in real life is shaped by many rules, exceptions, and legal interpretations that can make organizing tricky. One big reason for the complexity is how the law itself is written. The National Labor Relations Act sets out specific steps workers must follow to organize a union. They have to hold elections, file unfair labor practice charges, and follow strict timelines. These steps involve detailed paperwork and formal procedures that must be followed exactly. If workers or unions make even small mistakes, their efforts can be delayed or stopped altogether. Another reason is who the law protects. The National Labor Relations Act does not cover all workers. Supervisors, managers, and independent contractors are usually excluded. This means if a worker is classified as a supervisor or independent contractor, they don't have the right to unionize under this law. Employers often try to classify workers in these ways to limit the number of people who can join a union. Disputes over these classifications can lead to long legal fights. The law also allows employers to respond to union efforts in certain ways. They can hold meetings, distribute flyers, and share their opinions about unions. As long as they do not threaten or intimidate workers, these actions are legal. But the line between legal and illegal employer tactics is often blurry. Employers might schedule mandatory meetings or change work conditions during union campaigns, which can discourage workers from supporting a union. These tactics are often legal but can still make organizing harder. Enforcing these laws adds more layers of complication. The National Labor Relations Board oversees union elections and investigates unfair practices. But the process can be slow, and penalties for violations are often limited. For example, if an employer illegally fires a worker for supporting a union, the National Labor Relations Board can order the worker to be rehired and paid back wages. Still, there are no criminal charges or hefty fines. This makes it easier for employers to take risks, knowing the consequences might not be severe. In recent years, new challenges have appeared. The rise of gig work and non-traditional jobs makes applying old laws more difficult. Many gig workers are classified as independent contractors, which means they are not protected by the National Labor Relations Act. There are also debates about what it means to be a joint employer, which affects who is responsible for bargaining and who can be held liable for violations. Finally, state and local laws can add to the confusion. Some states have laws called right to work, laws that let workers opt out of paying union dues, even if they benefit from union contracts. These laws can weaken unions financially and make it harder for them to representing workers effectively. All these factors mean that workers trying to organize a union need a good understanding of the law. They often need legal help to follow the right steps and respond to employer tactics. This makes union organizing a process that can take a lot of time and effort, even when workers are eager to form a union.